Welcome everyone wholeheartedly on behalf of Indian Institute of Industrial and Professional Studies. First, I would like to welcome our speaker for day, Advocate Jaydeep Mehta, sir. Thank you so much for being here and spending your weekend with us. So I would like to introduce sir to the quorum here. So he's a qualified lawyer from the University of Mumbai and as well as a qualified independent director and a dynamic professional with extensive experience of nearly 29 years in legal and secretarial corporate and general affairs, having expertise in the areas of corporate legislation, drafting contracts and agreements, and legal compliance. He is a keen analyst with exceptional skills in litigation as well as non-litigation matters. He is a founder of promoter of Lex Street Advisors LLP, Advocates and Solicitors, a full-service law firm. And personally, I would like to add one more thing here that with due respect to all other senior advocates, when in comparison of sir with those people, sir is very much down to earth, and also he has attended many of the sessions, not as a speaker, but as a participant. And he was very open that, yes, I would like to hear all of you. And I have one of his mails, which he has composed in a very well manner. And he has said that I'm here for knowledge purpose and other things, which really touched all of us. And I think this is what we should learn from him. And by his actions, I can clearly make out that he's a person who believes learning is a never-ending process. And I am extremely privileged to welcome you on behalf of IIPS India, sir, and all the participants here. I have a confirmed trust, and it is not just I'm hoping or something like that. I'm very much sure that at the end of the session, you'll be taking so much of knowledge with you and so much of information which sir is going to share with us. Thank you so much, and it is over to you, sir. So you are on mute.
Thank you, everyone, and especially thank you, IIPS India, for inviting me today on Sunday afternoon. And also thank you, I thank all the participants who have made it possible to attend today's session. So, of course, it's a very big now upcoming topic, arbitration. Many practitioners say they are arbitrators, mediator, conciliator, but it's a very, very big concept, very upcoming concept, and even nobody is expert in this. As Madam said, everybody is a student as far as our profession is concerned. So is my screen now open on the screen?
No, sir, the screen is not yet visible.
It is already shared, no? 1 minute. 1 minute. Screen is already shared. It is not on the, not visible.
No, sir, no, sir. Can you please stop sharing and reshare with the entire screen option?
Okay. Exit full screen. Okay. A window. One minute. Okay, is it open now? Is it visible now?
No, sir, it is not visible actually. Yeah.
Okay.
Yeah, it is visible now, sir.
Okay.
Yeah.
So let me start. Thank you, everyone. Let me start with this anecdote. So if you want to prolong a dispute, litigate, and if you want to resolve a dispute, arbitrate. I don't know practically how far it is possible, but this is what I normally say. So before I come to our today's topic, let me brief you about the existing judiciary system. What exactly is the position in our judiciary, Indian judiciary? So see the status of the pending cases in various district and taluka courts across India. You can see about total number of cases pending about 4.11 crore in various districts and taluka courts in India. Out of this, there is a bifurcation also. I have made how many cases are pending for more than 1 year. And there are few cases which are pending even for more than 20 years, 25 years, 30 years. So about 3.20 crore cases are pending for more than 1 year. Similar is the case status of pending cases in various high courts. You can see how the total number of cases pending in various high courts across India. So about 58.88 lakh cases. Even in Supreme Court, these are the figures I have taken as of yesterday evening. Even in Supreme Court, Honorable Supreme Court, as on today, 70,000 plus cases are pending. And if we go by the summary, about 4.71 crore cases are pending in Indian judiciary as on today. So this is the possible, and the serious issue is how fast we can deliver the justice delivery system, how far we can improve. And it all depends on the professionals like us as well as the bench. So it is the joint responsibility of bar as well as the bench to improve the justice delivery system of our country. So now let us, the huge pendency, you can just see 4.71 crore cases are pending in various courts across India. So let me brief you about the Honorable Justice N.V. Ramana's anecdote. So what he says, let me read it in front. It is in front of the screen. Let me read it. The wordings, the inverted comma, the wordings of Honorable Chief Justice of India, the current Chief Justice. My advice, after participating in the legal profession for over 40 years in different capacities, is that you must keep the option of going to courts as a last resort. Use this last resort only after exploring the option of ADR, that is alternate dispute resolution, what we call it. Arbitration, mediation, and conciliation. Arbitration and mediation are efforts at restoring a relationship. I think that the most important factor behind the resolution of any dispute is having the right attitude. By right attitude, I mean we should leave aside our ego, emotions, impatience, and embrace practicality. But once these conflicts enter a court, much get lost in the practice and procedure. So what a beautiful statement our Honorable Chief Justice has given to support the alternate dispute resolution mechanism in the country. So what he says, the court should be the last resort. Let me come to the now journey of arbitration, how it began. If you see that the first Arbitration and Conciliation Act was introduced way back in 1899. So that was mainly for the presidency town of Mumbai, Calcutta, and Chennai. Subsequently, another Arbitration Act was introduced in 1940. And finally, the present Arbitration Act, which we are now seeing, is the Arbitration and Conciliation Act 1996, which was subsequently amended many times. Recently, it was amended in 2015 and then 2019 and again in 2020. We will come to that amendments also as and when we progress in this. So Arbitration and Conciliation Act 1996, so it is basically based on the UNCITRAL model of law. That is, UNCITRAL model means the United Nations Commission on International Trade and Law. If we go by the preamble to the Constitution, you will see how many times the terminology UNCITRAL model has been used. I will show you that also. So with the rapid globalization of Indian economy, as you all are aware that Indian economy was open to the global, globally way back in 1991 when by the then Finance Minister Dr. Manmohan Singh, and many Indian companies have also have crossed the border of India, and similarly many MNCs have also entered India, and which have ultimately given rise to many disputes amongst the various corporates, trading communities. So it was enacted in 1996, which ultimately came into force on 22nd of August 1996. It extends to the whole of India, even now the state of Jammu and Kashmir. So let us see the preamble to the Arbitration and Conciliation Act. You will see how many times the ancestral model has been used. Whereas the United Nations Commission on International Trade, ancestral, whereas the General Assembly of the United Nations has recommended that all countries means all those countries who are member of United Nations, they give due consideration to the said model law. And whereas the UNCITRAL has adopted the UNCITRAL conciliation rules in 1980, so you will observe that how many times the UNCITRAL model has been utilized in this particular preamble. So basically, I would advise everybody that whenever you get an opportunity, please go through the UNCITRAL model law. So entire Arbitration and Conciliation Act of all the country who are members of the United Nations, this particular act is based on the UNCITRAL model law of arbitration. So what are the basic objectives of the act? So as everybody is aware, to provide fair and efficient and speedy procedure for settlement of commercial disputes, to deal with international and commercial arbitration, to provide rules and responsibilities. So I will not deliberate on that. So I will come to the structure of Arbitration and Conciliation Act. So it looks a very small act. It contains only 86 sections in 4 different parts and contains 7 schedules. So the basic provisions of arbitration are contained in Part 1. Part 2 deals with the enforcement of certain foreign awards. That sections provisions are contained in section 44 to 60. Part 3 of the Act provides for conciliation under section 61 to 81, and supplementary provisions are there in sections 82 to 86. So the Act is very small, but there are so many issues involved, including legal technical issues are involved in this Arbitration Act. So I will not deliberate on this. Schedule 1, which contains deals with Convention on Recognition and Enforcement of Foreign Award. Schedule 4 is important because it contains model fee structure of arbitral tribunal. Basically, every arbitral tribunal follows this model fee structure. Schedule 5 provides grounds for justifiable doubts as to independence or impartial of arbitrators. So let us now start actually what some of the important definitions which are given under the Arbitration and Conciliation Act. So what we are talking about arbitration. So the Act section 2, it defines arbitration of Arbitration and Conciliation Act. It defines in a very simple sentence that arbitration means any arbitration whether or not administered by permanent arbitral institution. So in fact, I fail to understand the intent of the legislature. What do they mean by a single line definition? So it's difficult to understand what exactly arbitration means. So this definition raises many issues, like what are the subject matters of the arbitration? What could be the arbitration? Basis of arbitration? Whether all disputes can be referred to arbitration or not, or only certain kind of disputes can be referred to arbitration. There are so many issues involved. So if we understand from the layman's language, so what exactly arbitration is, as everybody knows, that it is basically a flexible process for resolving disputes, especially the disputes which are arising in day-to-day business transactions, in a binding and enforceable manner, where parties refer their disputes to a third party, which is, we call it arbitral tribunal, whether it is a sole arbitrator or an arbitral tribunal. So the legal definition is very confusing and difficult to understand the intent of the legislature. So let us go further. So what could be the subject matter of arbitration is a very big question. So if we look at the provisions of that, nowhere it is defined. There are no specific provisions under the Arbitration Act which specifically says that this dispute can be referred to arbitrator. These certain disputes cannot be referred to arbitral tribunal. So it is subject matter of dispute, arbitration. So basically, in general terms, so based on my experience, if we deliberate upon what disputes can be settled by arbitration, so normally all kinds of disputes which involve commercial, civil and labor related issues, disputes in respect of which the parties are entitled to conclude a settlement can be settled by ADR procedure, that is alternate dispute resolution mechanism. So again here I would like to deliberate ADR, we call it alternate dispute resolution, which we normally include terminologies like arbitration, conciliation, mediation, negotiation. But the Arbitration and Conciliation Act talks only about two terminology, that is arbitration and conciliation. Though the mediation and negotiation are not part of the legal provisions of ANC Act, we in our day-to-day language professional use all the four terminology is a part of alternate dispute resolution. So basically disputes of civil nature, quasi-civil nature involving civil rights fall within the jurisdiction of arbitration. So the question arises, so what kind of disputes cannot be referred to arbitration? So as a matter of public policy, so disputes which arises out of matrimonial matters or criminal proceedings, insolvency, winding up of the matters, winding up of the companies, competition matters are normally not arbitrable. That is what the general perception is, though there is no specific legal provision under the Act about the reference of disputes to arbitration. So again, if I have to elaborate further, so dispute involving joint ventures, construction projects, partnership differences, intellectual property rights, personal injury, product liabilities, professional liability, real estate transactions, or interpretation of various contracts, insurance claim, banking, non-banking transactions. These are all the general I have mentioned here, which can be normally can be referred to arbitration. Disputes beyond jurisdiction of arbitration, as I have already mentioned in earlier slide, that in any case dispute involving criminal offences are fully beyond jurisdiction of arbitration. So recently section 8, if our learned friends may be aware, section 8, the provisions of section 8 of the Arbitration Act has been amended. I will come to that, which deals with the reference of matters to arbitration. So we will deliberate upon that particular section 8. Disputes beyond, so these are the disputes beyond arbitration jurisdiction. Now matters bailed for adjudication are by arbitrator. So now let me further elaborate on this particular topic. So let me discuss one very beautiful judgment, which was a very old judgment of arbitration, but it is a very interesting judgment. So in this particular matter, Prabharata Commercial Cooperative Corporation Limited versus Dandiya Current Project Limited. It was a project of Government of India, and the dispute arose between this government project, Dandiya Current project, and the contractor. What was that dispute? It is a very interesting matter. So in the contract which was entered into between this contractor and the government, this particular project, there were two separate clauses. The clause 13A, which said that the dispute relating to the pricing of between the contractor and the project will be deliberated upon by the senior engineer of the particular project, and other disputes will be referred to the arbitral tribunal. Now the problem was, the question arose between the dispute arose between the contractor and the government as regards certain matters, and the matter went to the Supreme Court ultimately. So I would like to particularly read that particular judgment of the Supreme Court. Let me come to that. So in appeal filed in the High Court under section 39 subsection 1 clause 4, that was under the old Act of Arbitration Act 1940, the respondents contended that, I am just reading the particular judgment of the Supreme Court. The respondents contended that the dispute regarding rates came within the ambit of clause 13A of the contract, and the clause provided that in the event of the dispute, the decision of the superintending engineer of the circle shall be final. The respondents further pointed out that the arbitration agreement was contained, the main arbitration agreement was contained in clause 14, and that the clause specifically excluded any dispute arising under clause 13A. So the dispute related to pricing was included in clause 13A, and actual and arbitration agreement was in clause 14A. So the learned judge of the High Court held that the clause 14 containing the arbitration agreement had no application to the dispute in question, which fell under clause 13A. So there were confusion between two clauses, 13A, clause 14. Main arbitration agreement was in clause 13 in this particular case, and another related to price was in 13A. And therefore the arbitrator had no jurisdiction in the matter, and that was ultimately upheld by the Supreme Court. So that is the judgment which I wanted to deliberate upon. So this I do not want to deliberate right now. This is again, as far as I am emphasizing the subject matters of arbitration. So even though there is a arbitration agreement in the contract between the two parties, the importance of the subject matters of the arbitration is very important. So let me discuss. This is a very interesting case once again. It is a case of Kingfisher Airlines versus Captain Prithvi Malhotra. So what has happened in this matter is that, as you are all aware, there were so many disputes in the Kingfisher Airlines very recently. The Kingfisher Airlines stopped paying salary to the employees, and one of the employee, he filed a application to the industrial dispute under the labor court, under the Industrial Dispute Act. Now what has happened, the provisions of section 10A of the Industrial Dispute Act 1947 mentions that there is a clause in the particular ID Act that the employers and workmen can voluntarily agree to enter into an arbitration agreement to solve their disputes through the process of arbitration. However, if any employee does not fall under the category of workman, then he can, through the agreement of arbitration, can refer to the arbitral proceeding between employer and employee. So let me inform you what was that clause between employer and employee. Let me read that clause. Just let me read that clause. So or I will share 1 minute. So, or let me read. So, clause in the employment letter which was issued by Kingfisher to that particular employee, the particular clause 17, it stated that all disputes, I am reading the clause which was there in the appointment letter. All disputes relating to the validity, interpretation, enforcement, or breach of the terms and conditions of appointment arising between you and the company, that is arising between the employee and the company, shall be decided by arbitration in accordance with the provisions of the Arbitration and Conciliation Act 1996 as substituted or amended from time to time. The chief operating officer or such official of the company or any third party as may be nominated by the chief operating officer shall be the sole arbitrator. The venue of arbitration shall be at Mumbai or any other place designated by the chief operating officer of the company. The award of the arbitrator shall be binding. This was the clause which was included in the contract between the company, that is Kingfisher, and the particular and the captain. The dispute arose in this particular case. The dispute arose between Kingfisher Airlines Company and the captain, and that captain filed an application in the labor court. The company also appeared in the labor court, and very interesting matter, please listen carefully. The company filed an application in the labor court under section 8 of the Arbitration Act that was invoked by the company, that the matter should be referred to the arbitration only as per the contract between the company and the employee. So the section 8 of the Arbitration and Conciliation Act was invoked, as the agreement allowed it to refer to arbitration in case of dispute, but the said contention was revoked by the labor court and retained the jurisdiction over the proceeding. The company filed an application before the labor court, and the labor court took a decision that this dispute is this matter pertains to the labor court. It is a matter of Industrial Dispute Act. Though there is a clause between the company and the employee that any dispute should be referred to arbitration, in spite of that clause, the labor court in this particular matter rejected the application of Kingfisher Airlines and allowed the application of the employee. Against this order of the labor court, the Kingfisher Airlines moved the Bombay High Court with the contention that the decision was quashed again, and it was held. I mean, the Bombay High Court also took the same decision which was taken by the labor court. So it is a very important that what I mean to say that this, even though there is an arbitration clause between the parties, and even if it exists between the parties in the contract between the two parties, what is important here is the subject matters of arbitration. So when we draft the contract and when we include the arbitration clause between the parties, the drafting is very, very crucial. So in this particular case, even though there was an arbitration clause and which specifically stated that in case of any disputes and that was mentioned in the employment letter, the specific clause was included in the employment letter issued by the company Kingfisher Airlines to the employee. In spite of the fact that this particular subject was not considered as part of the arbitration clause, and the decision of the labor court to deal with this matter was upheld by the Honorable High Court of Bombay. So I will be sharing the judgment, but this is the synopsis of the case. So let me now come to the arbitration agreement. So what is the what is the meaning of arbitration agreement? Because we, our day-to-day professional life, we keep on using there is a arbitration agreement. So what exactly is? So it is defined under section 2B of the Arbitration Act. So according to section 2B, it simply states that arbitration agreement means an agreement referred to in clause section 7. So now again we have to go back to section 7. What section 7 of the Arbitration Act states? It states that section 7 defines arbitration agreement as an agreement between the parties to submit to arbitration all or certain disputes. I am putting an emphasis on these particular words. To submit to arbitration all disputes or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. So arbitration, and further states that an arbitration agreement may be in the form of an arbitration clause in the contract or in the form of a separate agreement. So arbitration agreement may be one of the clause in the entire agreement of the entire contract between the parties, or there can be a separate arbitration agreement which can be entered into between the two parties. So arbitration agreement shall be in writing. So this is one of the important provision. It shall be in writing. So what writing means? It can be signed, a document signed by the parties, or maybe exchange of electronic exchange of communication through electronic means, and exchange of statement of claims. So we will not go much detail into it, but it has to be in writing. So now that was the legal definition of an arbitration agreement. So what are now the attributes of arbitration agreement? So what could be the approach of the court when the matter goes to the court? So to avoid any confusion at a later stage whether a particular clause is arbitration clause or it does not fall under the arbitration clause, certain points are very important which I have deliberated in the 3 points I have given, which are very important, which should be taken care of. The intention of the parties to settle their disputes by means of adjudication by a private tribunal must be clearly stated. So when we draft an agreement, specific, extra care should be taken to ensure that whenever dispute arises between the parties to the agreement, the intention of the parties have to be very clear. So I will also be discussing a very interesting case on the intention of the parties. The clause must indicate the present or future differences or disputes that have arisen or may arise between the parties in connection with their dealings shall be referred to arbitration, and it should be clearly indicated that the decision of the arbitral tribunal shall be final and binding on both the parties. So these are the three are very important attributes of any arbitration agreement. So there are some other also which I would like to tell apart from, but these three must be there. So intention of both the parties should be very clear that in case any dispute arises, the intention should be very clear that the dispute shall be referred to the arbitration. So I will deal with that intention of the parties in one of the very interesting judgment which I have come across very recently. A judgment of the Delhi High Court very recently. I will come to that in a later slide. So I would like to further elaborate that whenever we draft an agreement, whenever you draft an agreement on behalf of your party, the other certain important aspects should also be taken care of. Apart from these three compulsory clauses which should be taken care of. So another important other incidental matter which should be taken care while drafting an arbitration clause, either in the main contract or it can be a separate arbitration agreement between the parties. So what should be the procedure to be followed by the parties before invocation of the arbitration clause? That should also be clearly mentioned in the arbitration clause. Number of arbitrator, whether it will be a sole arbitrator or it will be referred to the institutional arbitrator, that is another matter which is important. Qualification required for becoming a member of the arbitral tribunal. Now, I would like to further deliberate on that. So till now, there was a particular schedule which prescribed the qualification of an arbitration. But in the recent amendment of 2019 and 2020 perhaps, the qualification has been removed now. So now it only states that, let me read that particular clause. I think it was, exactly, I don't remember the particular section, but somewhere in recent amendment of section 242 AB, which stated that the qualification of arbitrator shall be as may be specified. So as of today, that particular schedule which formed part of the Arbitration and Conciliation Act has been removed, which prescribed the qualification of an arbitrator. But as on today, it simply states that the qualification of arbitration will be such as may be prescribed in the regulation. But so far there is no specific qualification which is now in existence in the arbitration agreement. So if you can go through earlier schedule, it prescribed particular qualification for the arbitrator, like practitioners, like practicing chartered accountant, practicing lawyer, practicing company secretary, cost accountant, having 10 years of practice, can be an arbitrator, shall be an arbitrator. But that particular clause has now been removed from the in the subsequent amendment in 2019. The period which an appointment ought to be made, the period within which the appointment should be made, venue of the arbitration, language of the proceeding, which is of course now common language is English only, the time limit for finalization of award, which is already prescribed in the arbitration agreement, the law which would govern the parties and the court, that is, it is basically the contention. This particular subject matter arises in case of international commercial arbitration. These are some of the common for drafting certain points I have prescribed. So I will not deliberate it. I will share this PPT with you. So basically, I would like to deliberate on some of the couple of judgments which are very useful to all of us. This again pertains to notice for arbitration. Yes, now the dispute is arisen, then what is the next immediate step for invoking arbitration? The first step is to issue. Now one of the parties has decided to invoke arbitration. So the legal provisions are contained in section 21 of the Arbitration Act. The notice of arbitration is mandatory and it has to be issued to the other party. The notice should contain all the details. If you are recommending any arbitrator, the name of the arbitrator should be mentioned, or the name of 3 arbitrators should be mentioned, so that the other party gets an opportunity to select the arbitrator. So in this particular point, I would like to mention the judgment of Honorable High Court of Delhi, a February 2017 judgment, where the Honorable Justice Muralidhar, in the case of Alupro Building Systems Private Limited and Ozone Overseas, it is displayed on the screen, you can read it. has given a much needed interpretation and clarity to the subject and purpose of issuing the notice under Section 21 of the Arbitration Act, holding that the provisions under the Section 21 of the Act are mandatory in nature and cannot be dispensed with, and forms the preceding act in the initiation and reference of the disputes between the parties. It was further held that the provisions of Section 21 are not limited only for the purpose of determining the limitation, and a party cannot straightaway file a claim before the arbitrator without issuing the notice under Section 21 of the Arbitration Act. So this judgment clearly states that issuing notice to the other party for invoking arbitration is mandatory. So I will not deliberate further on that. Notice is a prerequisite. Notice must be addressed to the proper authority and send it to the designated office address. So here just further, if I elaborate, if the one party is sending notice to the company, so in that case, please ensure that the notice is sent only to the registered office of the company, which is available in the record of the Ministry of Corporate Affairs. You may be aware that the corporate office is in Mumbai, but the registered office may be situated in some remote place, in some other village. But the notice has to go to the registered office address, which is available in the record of Ministry of Corporate Affairs. It should be also mentioned that all precondition, procedure, etc. should also be mentioned in the notice. So these are some of the general terms which I feel should be included in the notice when we send notice to the other party. Existence of disputes, I will not much deliberate on this. Of course, when the dispute arises, then only the arbitration clause will be invoked. Interim measures, do you want me to deliberate on this particular topic? Because there are the provisions related to interim measures which are available when the arbitration agreement, when the arbitral tribunal procedure starts. So the party who is seeking the invoking the arbitration agreement, he may expect some interim measures by the court. Then in that case, an application has to be made under Section 9. So here there are two separate sections. Section 9 deals with the interim measures which can be granted by the court, and there is another Section 17 which normally deals with the interim measures which can be granted by the arbitral tribunal. So interim measures by the court as well as by the arbitral tribunal are dealt separately under different sections. So application can be made to the court for availing of interim measures. So I will not much like to deliberate on that, but I would like to emphasize on the provisions of Section 16 relating to the jurisdiction of arbitral tribunal. So these provisions are very important according to me as far as the jurisdiction of the arbitral tribunal is concerned. So what it states that the arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to existence, that is fine. But let me refer to clause A of subsection 1 of Section 16. An arbitration clause which forms part of a contract shall be treated as an agreement independent of the terms of the contract. So I would like to elaborate further on this particular clause, because let us assume that there is a main contract entered into between two parties, say Company A Limited and Company B Limited, and for some reason the contract is terminated. One of the party terminates the contract. then what in such circumstances, what happens to the arbitration clause, which is contained in the main contract entered into between the parties. So this particular provision specifically states that the arbitration clause, which forms part of the contract, shall be treated as an agreement independent of the terms of the contract. And clause B further states that a decision by the arbitral tribunal that the contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. So what this provision state that if there is a contract between the two parties and for any reason, so let me give you a very concrete example. After the pandemic, after March 2020, there were disputes between the two parties in majority of the contracts, and in many cases it has happened that one of the parties has terminated the contract with the other party. So in this particular situation, what happens to the arbitration clause? Arbitration, even if the main contract is terminated, the legal validity of the arbitration clause will remain. So if there is any dispute by one party exists, and if he wants to go invoke the arbitration clause, he can do so and invoke the arbitration even if the contract is treated as null and void, even if the contract is terminated. The legal validity of the arbitration clause will remain. So to further elaborate, subsection 2, let me read that. A plea that the arbitral tribunal does not have the jurisdiction and shall be raised not later than the submission of that is fine, that you can always read. So the main provisions which I would like to deliberate is again, the one is the intention of the parties, which I discussed earlier, and second is section 16 about the jurisdiction of the arbitral tribunal, which categorically states that even if the main contract is terminated, the arbitration clause, even if it forms part of the main contract, it will survive. So I would like to take our learned friends to one of the important judgments which I have come across very recently. So very brief synopsis I have made. So, and I am sure it will be helpful in understanding many important aspects of the arbitration. Let me share. One minute. Yes, future video. So this 1 minute, where is the sharing option? Okay. So it is visible, no? Screen is visible.
Yes, sir. Yes, sir. The screen is visible.
So now I would like to share another screen.
Okay.
So can you guide me?
Yes, sir. You please open that. Actually, you close this PPT, sir.
Okay.
Yeah, you close this. Yeah, now please open that file and start sharing.
1 minute. Let me.
So any questions you can ask at the end of the session.
1 minute. So I mean, I think it is not shared yet.
Okay.
Can you see the screen?
No, sir. No, not yet.
1 minute. Okay. Let me share this window.
Yeah, share that entire window.
So now this is the 1 minute. No, not place of arbitration. 1 minute.
Yes, it is visible now, sir.
No. I am not. I don't know. I am not sharing this particular 1 minute.
You can minimize that one and you can open that.
1 minute. 1 minute.
Yeah.
Okay. So this is a very recent judgment, just 3 days back, Honorable High Court. I have prepared a synopsis of this particular judgment, and it is very important judgment. And I am sure if we deliberate upon this judgment, many of the important provisions of the Arbitration Act will be cleared. So a judgment which was delivered on 12th of April 2022, just 3 days old judgment of Honorable High Court of Delhi. So it is regarding sufficiency of stamp duty on agreement and the nature of contract cannot be adjudicated by the court under Section 11 of the Arbitration and Conciliation Act. So Section 11 deals with the appointment of arbitration, and which I think our learned friends can always read that the provisions of Section 11. But here I would like to deliberate upon, analyze the judgment. So the brief synopsis I have made, which will clear many doubts. The single bench of Justice Vibhu held that the dispute as to whether the contract containing the arbitration clause is sufficiently stamped or not, and the nature of the contract are contentious issues which cannot be decided by a court in a petition filed under Section 11. A live example, I would like to analyze this particular judgment along with the name of the parties, because it is very interesting judgment, which according to me it is very interesting and will be helpful in understanding many provisions of the Arbitration Act. The company called Persona Developers Limited, we will call it PDL, entered into an agreement with Delhi Metro Rail Corporation Limited, whereby a specific area was allocated to PDL for constructing a shopping complex. PDL was given the right by Delhi Metro Rail to further sub-license the allocated area. So thereafter, the PDL entered into a sub-license agreement with Future Retail Limited, FRL. After the enactment of the Finance Act 2017, renting and licensing immovable properties for commercial use was made eligible for service tax. So it also involved not only the contract dispute for Contract Act, but also the service tax. PDL called upon the FIL, that is Future Retail, to reimburse the service tax paid by PDL. However, FRL denied its liability to pay service tax under the contract. After this, PDL invoked the arbitration clause and filed a petition before the Delhi High Court under Section 11, subsection 6 of the Arbitration Act for appointment of an arbitrator after FRL failed to nominate arbitrator. The procedure was followed. Notice was issued to Future Retail. Future Retail did not reply, and therefore PDL invoked arbitration clause and nominated an arbitrator. FRL contended before the Honorable High Court that the contract entered into between PDL and FRL was insufficiently stamped, and since the arbitration clause was incorporated as a part of the main contract, the recourse to courts in respect of the said clause, that is the arbitration clause, was not available. FRL counsel contended that the main contract was insufficiently stemmed, and therefore the arbitration clause contained in the main contract is not applicable. So FRL submitted to that the contract was required to be compulsorily registered. Another issue arose regarding registration of the contract. And since it was an unregistered document, the same would not affect the rights and obligation of the parties. Also, FRL averred that the dispute raised by PDL were barred by Limitation Act 1963. So it involved dispute regarding service tax, Limitation Act, Contract Act, so many multiple issues. The counsel for PDL, that is the petitioner, submitted that the contract was in the nature of a leave and license agreement and was sufficiently stemmed. The counsel further added that the question of validity of an agreement fell within the jurisdiction of the arbitral tribunal, and scope of the examination under section 11 is limited by virtue of so and so, so and so. The counsel relied on the judgment of the Delhi High Court in the case of so and so, wherein the High Court had held that the question whether the agreement is a lease or license is a triable question. So let me come to the main issue now. The High Court observed that the Supreme Court in the case of N Global Mercantile Private Limited versus Indo-Unique Limited and others held that the non-payment or deficiency of stamp duty does not invalidate the main contract. That was the judgment of the Supreme Court in this particular case. Now this is very important. In this particular judgment of Delhi High Court of 12th April 2022, the High Court held that even though an arbitration agreement is embodied in a main agreement, it is a separate agreement, and invalidation of the agreement, that is the main agreement, does not necessarily invalidate the arbitration clause. Also, an arbitration agreement is not required to be compulsorily registered. The court ruled that the following the doctrine of severability, the benefit of an arbitration agreement cannot be denied to any party on the ground of any deficiency in the main agreement. So whether the main agreement is valid contract or it is invalid contract, it will not invalidate the arbitration clause. So the issue is very clear. The court observed that the dispute as to whether the contract was sufficiently stemmed or not and the averments made by PDL with respect to the nature of the contract are contentious issues which are required to be adjudicated by the arbitral tribunal. So it is a very beautiful judgment according to me. Should I come back to my main close again petition? 1 minute. So this is okay. So this is where is it available on the screen?
No, sir, we are still in Word.
Still in Word, okay. Okay, so this I wanted to deliberate upon one important judgment. So some other, I will share with you the entire PPT because some of the important, if any participants also want to have some interactive session, we can always have. So that is Let me now deliberate. Just briefly, I will go through some of the important amendments which was introduced in Arbitration and Conciliation Amendment Act 2015. This came into force on 23rd of October. So one of the major objects of the amendment was to provide a quick procedure that prevents undue delays in dispute settlement procedure. And for the first time in this particular amendment of 2015, the fast track procedure for arbitration was introduced. So that was in 2015 amendment. Again, another amendment was introduced in 2019 Amendment Act. So this came into force on 9th August, that is fine. Inter alia, it excluded international commercial arbitration from the purview of the timeliness provided in this section. So normally the arbitration has to be completed within a period of 12 months from the completion of pleadings by both the parties. The time limit is 12 months from the completion of pleadings by both the parties. Arbitration has to be completed. So earlier it was 12 months from the date of entering reference by the arbitrator. Entering reference means earlier it was 12 months from the date of appointment of an arbitrator, which was now subsequently amended. And now the arbitrator, it says that amended act says that the arbitration has to be completed within a period of 12 months from the completion of pleadings by both the parties to the agreement. Of course, there is a provision for extension also. In this 2019 enactment, two sections were introduced, Section 29A and Section 29B. The arbitral tribunal shall make an award within a period of 12 months from the date of completion of pleading. That was included in this amendment. Earlier it was from the date of appointment of arbitral tribunal. Section 29A, as far as a time limit is concerned, it does not apply to international commercial arbitration, which in this particular presentation I would not like to discuss on international commercial arbitration, but as far as time limit is concerned, it only states that in case of internal commercial arbitration, arbitral tribunal shall make an award as early as possible, and an endeavor may be made to dispose of the matter within a period of 12 months. So in case of international commercial arbitration, time is not, there is no compulsion as far as time limit is concerned. I would like to go through, if the time permits, if our learned participants agree, I would like to show 2-3 video clips. If the organizers permit and participants permit, will it be okay?
Yeah, sure, sir, sure.
The purpose is that recently in the last week, that is on 9th of April and 10th of April, the judicial conference was organized by the Honorable High Court of Bombay, and the Honorable President of India was also present. Honorable Chief Justice of India was also present. Some of the sitting judges of Supreme Court were present, and many judges of various high courts of India were present, and some important, very interesting deliberation took place. That is what I wanted to display just a 1 week back, last week. Which 1 minute, let me see. Is screen visible?
Most helpful. No, sir, not yet.
It is not visible. 1 minute. So the live, if I want to share this live YouTube, will it be possible?
I think it should be possible, sir. You have to switch to YouTube now. Like the screen is still in the PPT. I think it should be playing in the YouTube thing.
1 minute. Let me. I will show you a very important, which I would like to. 1 minute. If I can share it, let me see.
Okay. Yes, sir.
I don't know whether. Is it visible?
Not yet, sir.
Not yet. 1 minute. Is it visible now?
Yes, sir, it is visible.
Yes. Okay. So one more. One where I would like to particularly emphasize, listen this carefully now.
Okay.
Important conferences, which is so long working in every sphere of life. The use of information technology in justice delivery system. That our government is giving full attention on both these subjects.
Can you listen it?
It is not clearly audible, sir. We can see it, but it is not properly audible.
Not
Introduced in the
audible.
So please do share the link with me, sir, so that I can share that to
Okay.
all the participants individually, and you can brief what you want to say about it.
Fine. So my PPT is quite long. So many topics I have covered. Let me see if something more can be
Sure, sir.
deliberated. So judgments are very interesting. The act looks very small, but there are so many technical issues involved in that. The Honorable Minister only says that the mediation bill is at a very fast pace and likely to be introduced. It has already been presented to the Standing Committee of the Parliament, and the new mediation bill will shortly be introduced, and it will become an act very shortly. So, 1 minute now.
Yeah, can we jump into queries, sir? So we have some questions in the comment box.
So there are so many issues, but what I wanted to, in 1 hour, of course, it cannot be. If possible, we can even organize some course, a detailed course on arbitration.
Sure, sir, sure.
Something like certification course, or even wherever my help is needed, I am always ready to support IIPS.
Sure, sir, sure.
1 minute, and if question answer, of course, interactive session we can always have.
Yeah, so there are a few questions in the comment section. So the first question is by Mohit.
Okay.
So he has asked, can an arbitrator be made a party to the suit if it is evident that arbiter has been partial?
So can he be made, question is not clear, can he be made party to what?
Can an arbiter be made a party to the suit if it is evident that arbiter has been partial? So basically he meant that can action be taken against arbiter for being partial?
So that is, for that there are separate provisions. For he wants to say that he wants to challenge arbitration because he is not satisfied with the arbitral award. So there are provisions under section 34 for challenging the arbitration.
Mm-hmm.
And there is okay, next.
Next, again, one more question from Mohit. So he's asking, can a writ be filed to enforce arbitral award?
I would like to further elaborate. There are provisions contained under section 34 of the Arbitration Act for challenging the award. So there are various grounds which are given in the arbitral award. I have prepared that also. If possible, I can share.
Yes,
and
sir.
there's some judgment also I have selected, but due to paucity of time, it will not be possible because anyway, he can always go through provisions of section 34. I understood his question. He says that if can arbitrator be made a party to the suit?
Yeah.
But if I have to answer in my, yes, according to my knowledge and my understanding, arbitrator cannot be made a party to the suit, but arbitral award can always be challenged if he is confident that there are lacuna in the arbitral award and it is not uh, some of the provisions or some of the important aspects which should be considered while before giving an arbitral award were not considered. And recently there are many judgments. One of the very important topic, of course, now right now I cannot deliberate. It is a patent illegality.
Okay.
The award which has been passed suffers from patent illegality. So, in fact, I wanted to discuss that topic. What is patent illegality? And maybe in the next session, if you organize, we can deliberate on
Sure,
some.
sure.
So we can take up next question.
Sure. So Ajay is asking one more question. Can the decision of arbiter be challenged in court?
Pardon?
Can the decision of arbiter be challenged in the court?
Decision of the arbitrator.
Arbitrator, yeah. Decision of the arbitrator be challenged in the court.
So that is what I discussed in the just now.
Correct.
Section 34. There are provisions. It can always be challenged.
Yeah. So
challenging does not mean court will accept it. Let me give you one practical example which I have experienced very recently in my own case. The arbitrator has passed an award in favor of my client, and the opposite party's counsel filed an application before the Honorable High Court of Bombay. It challenged an arbitral award on the same ground that it suffers from patent illegality. Now, when the matter came on the board, unfortunately, I personally could not attend on that particular because I was busy in some other important matter and I could not attend, even though I was not present. Nor was any of my representative was there. The court directed the applicant that first you deposit the principal amount, then the matter will be taken up for admission, whether there is a case or not. Anyone who anyone who challenges an arbitral award, that does not automatically gives. Court does not consider it. First, court will ask you to deposit money. If you are challenging the arbitral award, first you deposit certain amount in the court, then the court will hear your petition. So that is the normal practical aspect which I have discussed.
Yeah. So any other person have any questions? You can even unmute yourself and you can ask to so.
So in fact, PPT is very long. There are about 82 slides I have made, but in 1 hour it is not possible.
Correct.
So maybe in some other session on arbitration, or we can ask. I would request also to the organizers if you can prepare one group on WhatsApp exclusively on arbitration, so we can deliberate upon various issues of arbitration.
True, sir. True.
So we can discuss on various judgments
of
Supreme Court and High Court. It is only a suggestion.
Sure, we'll do it, sir. Sure, we'll do it.
So,
Akash has a question. Yeah, Akash, please.
Good afternoon. Good evening, everyone. I just want to ask, after naming the arbitrator under Section 21 notice, and thereafter issuance of notice, if the opponent failed to reply, can we seek relief under Section 17 directly, or we have to go under Section 9 of Arbitration Conciliation Act?
No. I did not. So what, in simple terms, what exactly you want to ask? So you have sent a notice, other party has not replied.
Yes, sir. Yes, certainly. If he fails to reply my my notice under section 21.
In the
And
notice, have you referred any arbitrators?
yes, certainly, sir, I have mentioned the arbitrator name.
Right.
And
Whether
yeah,
it is one, two, or three. For example, just for
it
my
is a sole arbitrator, sir.
sole arbitrator. He has not replied. Then where is the question? Straight away you can appoint an arbitrator, same arbitrator.
And we can, and can we go? Can I go under section 17 directly?
Yes.
Certainly. Thanks a lot, sir.
Yes.
Yes, sir. There is one more question from Dilip Chetan. So
Right.
he's asking you basically, how can we minimize the intervention of court in the arbitration proceedings?
Court never, the purpose, what is the purpose of Arbitration Act?
Mhm.
The purpose is that the court does not want to intervene in the arbitration proceedings.
Mhm.
It is only, the court intervenes only when the aggrieved party who is aggrieved by the arbitration award, then only court interferes. If the for as long as the arbitration proceedings are going on smoothly, arbitration award is also passed, it is only the other party which will go to the court. Otherwise, court never wants to interfere. The purpose of arbitration is to reduce the burden of the court. That is why in the initial slide, I showed what is the position of our Indian judiciary system. When the 4.71 crore cases are pending, court does not want to take additional burden. So if the matters, as long as the matters are getting settled through the arbitrator or mediator or conciliator, court would not like to interfere.
Yeah. So in addition to that, I hope Dilip, your question is answered. Yeah, because he has given some more explanation. I hope it is answered, Dilip. Can you please confirm? Yeah.
Yes, ma'am.
I would also like to, inform all the participants that the last 2 days conference, which was organized by Honorable High Court of Bombay and inaugurated by the President, it is available online also. You can Google it on the YouTube. It is available. Just you type that All India Judicial Conference 2022. Both the parts will appear. It was 9th full day from 10:30 to 5 p.m. Full recording is available. The purpose of I wanted to show that Honorable Law Minister only said that the mediation bill is now getting ready and will soon be introduced. Another which I wanted to show that one sitting judge of Honorable High Court of Jharkhand, Justice Anubha Rawat, she has raised a query on mediation that she wants to undergo training for mediation, and she also said to the honorable sitting judge who are present there, Justice L. Nagaswar Rao, who was answering the question from the dais, though she said that there are many old matters which can be settled through mediation, and therefore, if possible, the training may be imparted to the judges of High Court so that the old matter, including some of the criminal matters which are, there is a possibility that it can be settled through mediation. That is what she wanted to inform. And third, which I wanted to display on this, is by the sitting Honorable Justice Bela Trivedi of Supreme Court. And she was deliberating upon Arbitration and Conciliation Act. And her concern is that why we need a separate mediation act when there is already an Arbitration and Conciliation Act. Why mediation provisions relating to mediation can be clubbed by amending the Arbitration and Conciliation Act. That was her concern. So that was the only three which I wanted to display, but it is the entire recording is available. There is even a live recording available of Justice Chandrachud also. So I will request all the participants, please go through it. Even if you cannot go through entire recording 5, 6 hours at a stretch, in piecemeal you can go, but it is very interesting conference. Yes.
Yeah.
Any other?
Yes, I hope there are no more questions.
Okay.
Yeah, one last time before winding up, we would like to hear for any feedback or any more questions.
So
Sir, actually, I had a question. This was a very incredible session. I had taken earlier also a session by you, and it was similarly nice. So the question was, why does we say this thing that India as a center of arbitration is yet to be developed, whereas we see Singapore, the court interference is very minimal. And what do you think are the gray areas where we should make a correction in that?
now see until even see we have seen that the the concept of arbitration was in earlier also. That is why there was an act of 1899. Then there was an act of 1940, and now we have an act of 1996. But arbitration momentum has picked up in our country, according to my opinion, maybe in the last maybe 8 to 10 years only. So that is the reason now the government is promoting arbitration, and that is why the International Center for Arbitration was inaugurated in December in Hyderabad, and recently in Delhi also. Now it is already started, and now even in our own international arbitration centers, matters are getting rather the arbitration is being promoted, and it is emphasized that now our Indian companies do not resort to Singapore and London or Hong Kong, because it is at the same time it is very, very expensive also even for Indian companies. Now if the opposite party, if it is a multinational company, and if they exist for Singapore International Arbitration, the classic case is Amazon and Future, which is going on in Singapore. So Indian arbitration centers are now being promoted even by the government itself, and government wants to promote Indian arbitration centers. So Hyderabad is one, there is one in New Delhi, there is now one in Mumbai International Arbitration Center. So there are many other local arbitration centers also, where I am also associated with two, three centers. But yes, Hyderabad, Delhi, Mumbai will become an international arbitration center, and particularly now with the opening of Gift City, there will be special international arbitration center for multinational companies. So of course now India will be a focal point even for MNC as far as arbitration is concerned.
Yeah, I hope Priyanka, your question is answered. So any more questions? And we have a bundle of thank you messages in the chat session, wherein they have applauded and they have expressed their gratitude. And we are also very much thankful for our speaker of the day. Sir, thank you so much for being patient and answering everyone's question, as well as I can easily make out the effort that you have put for making the PPT and the research work, as you mentioned, the statistics, etc. Thank you so much for that.
Welcome. I am also very happy that you have invited me. And
it's our pleasure, sir. It's our privilege that you are here.
And we can always make any WhatsApp group, Telegram group, whatever you feel. And sharing knowledge, as I always tell, knowledge is power, but sharing knowledge is empowerment.
Yes, sir.
So we can always deliberate on any topic. We can even recently we have formed one group for FEMA related matters.
Okay.
We have formed a group for corporate legal where I am running. We keep on sharing knowledge. So similarly, exclusively for arbitration, if participants are happy, we can do that also.
Sure, sir. Sure, sir. We'll surely do it. And yeah, thank you so much, everyone, for being here. And the e-certificates will be shared by Monday, as well as the recordings and the study materials as well. Thank you, everyone, and have a happy weekend.
Thank you.
Thank you so much.
Thank you so much.
I am logging off.